Hello and welcome to the College Investor Audio Show. 200,000 borrowers await Ninth Circuit ruling on $12 billion in student loan settlement. Okay, that's a mouthful, but that's what we're going to be talking about today. If you're part of this 200,000 borrowers, you want to stay tuned. Before we get to it, just a quick reminder that anytime you hear a topic on the podcast discussed, you can always find the article associated with it at thecollegeinvestor.com. And inside the article, there are PDFs, there's resources, there's all kinds of great information to dive deeper on any topic. You can also find us, like us, ask questions, comments, and everything at The College Investor. Search those words, and you're going to find us pretty much anywhere you are on social media. All right, 200,000 borrowers. Looking at the Ninth Circuit Court of Appeals. A federal appeals court heard arguments on March 20th, 2026, over whether the Education Department can further delay a court-approved settlement that promises loan discharges, payment refunds, and credit report corrections to more than 200,000 student loan borrowers who say they were defrauded by their colleges. Crazy. The case, Sweet v. McMahon, has been working through the courts since 2019. As a result, the case has changed names a few times. Sweet v. DeVos, Sweet v. Cardona, and now Sweet v. McMahon. The settlement, valued at up to $12 billion, set firm deadlines for the department to process borrower defense to repayment applications. The department has missed those deadlines and asked for extensions a whole bunch of times. So far, those requests have been denied. During Friday's hearing before the Ninth Circuit Court of Appeals, Judge Kim McLane Wardlaw offered a blunt assessment. Quote, "The time for negotiating is over. You missed your deadline." End quote. I like that. The court is now considering the department's motion to stay the settlement while it appeals. What is Sweet versus McMahon anyway, you might be asking? So Sweet versus McMahon, many times still referred to as Sweet versus Cardona, is a class action lawsuit filed during the first Trump administration. It accused the Education Department of delaying decisions on borrower defense to repayment applications, which is a federal program designed to provide debt relief to students defrauded by their schools. The College Investor team filed a FOIA request in 2023, which is the Freedom of Information Act request, and at that time, 59% of all borrower defense claims were still pending. Under the Biden administration, the department struck a settlement that established deadlines for processing applications and promised either timely decisions, whatever that means, or automatic relief to 3 groups of borrowers. A central piece of the settlement is Exhibit C, which is a list of 151 schools that the department identified as having strong indicators of substantial misconduct. Crazy. 151. Borrowers who attended those schools and filed applications during the class period were promised expedited treatment. Full settlement relief includes forgiveness of the borrower's federal student loan balance, refunds of past payments, and even correction or removal of adverse credit reporting. This relief is a contractual obligation under the court-approved settlement. Loan forgiveness claims delayed. The current appeal is the latest in a series of efforts by the Education Department to avoid meeting its settlement obligations. Here's how the timeline has unfolded. Late 2025, the department asked U.S. District Court Judge William Alsup for an 18-month extension to process borrower defense claims. So under the Secretary of Education, Nicholas Kent, argued the settlement, quote, imposes a timeline that would require the department to automatically cancel up to $12 billion in student loans by January 2026 without proper vetting, end quote. At the time, the department reported it was adjudicating about 1,500 applications per month, with roughly 193,000 applications still lacking decisions. December 11th, 2025, Judge Alsup ruled that applications involving Exhibit C schools must be adjudicated by the original deadline of January 28th, 2026. Oh boy. Or just be automatically approved. He called the 18-month request unacceptable. January 28th, 2026, the department missed the court-approved or ordered deadline, triggering the settlement's automatic relief provision for Exhibit C, post-class borrowers who did not receive decisions. February 24th, 2026. You tracking? The department filed a notice of appeal. You can actually see the PDF file if you want inside the article at thecollegeinvestor.com. And then on February 27th, filed a motion to stay in the Ninth Circuit. Then, March 20th, the Ninth Circuit heard oral arguments on the department's motion. The court's decision is now pending. All right, so all that said, here's what this hearing signals for borrowers. Judge Wardlaw's statement that the time for negotiating is over is a strong signal from the appellate bench. While the Ninth Circuit has not yet issued a ruling, the remark suggests limited patience for the department's ongoing attempts to delay. It's government. This is what they do. Delay, delay, delay. It's important to remember that filing an appeal does not automatically pause the lower court's orders, unless the Ninth Circuit separately issues a stay, which automatic discharges must proceed under the settlement terms. You can actually watch the hearing if you want. We have a link right there for you. It's kind of entertaining. But here's what this means for student loan borrowers awaiting loan forgiveness. If you filed a borrower defense application and you attended a school on the Exhibit C list, your situation depends on whether you received a decision by January 28, 2026 or not. Exhibit C post-class applicants who did not receive a decision by January 28th are entitled to full settlement relief. The Education Department must send you a notice of eligibility by March 30th, 2026. Your loan forgiveness and other eligible relief should be delivered within 1 year of receiving that notice. Post-class applicants who did not attend an Exhibit C school are owed a decision from the department by April 15th, 2026. Happy Tax Day. Meanwhile, borrowers need to continue to watch the outcome of this case and see how the court will rule. Never fear, we will keep our eye on it and will keep you informed every step of the way. Follow, like, subscribe, all the stuff that you can do on social media. We're pretty much anywhere you are. Just search for the words The College Investor and you'll find us. We'll make sure you're in the know and you stay in the know. Thanks again for stopping by today. That is our show for today, and we'll talk to you again real soon.